I'd like to call this meeting to order. This is meeting number 23, and we are studying the events related to the Mahar Arar situation, and we would like to welcome as our witness this morning the Honourable Anne McClellan, the former Minister of Public Safety. Welcome to our committee, and we look forward to the testimony you have for us.
Thank you.
The usual practice, as you probably are aware, things haven't changed much since you've been here. We usually allow you whatever time you may require, 10, 15 minutes, whatever, to make a statement, and then we will open it up to the official opposition, which at this time is the Liberal Party of Canada. Anyway, welcome, and you may begin whenever you are ready.
Thank you. Thank you very much, Mr. Chair. It is a pleasure to be back on Parliament Hill, and merci de m'avoir invité aujourd'hui.
Thank you for having invited me here today. I congratulate you and thank you for your follow-up on the O'Connor Commission report.
Take up the important task of getting to the bottom of what happened to Mahar Arar and why it happened. I think that his exhaustive investigation has served an important public purpose, but most importantly, perhaps, has provided the foundation on which Mahar Arar and his family can move forward. It is clear that what happened to Mahar Arar should not have happened, that mistakes were made. While it was not appropriate for me to meet with Mr. Arar personally during my time as Minister, I do want to take the opportunity now to express how sorry I am for everything that has happened to him and his family. It is now up to this government to decide how to implement Mr. Justice O'Connor's recommendations and to compensate Mr. Arar. My involvement with the Arar case began when I became Minister of Public Safety and Emergency Preparedness on December 13, 2003. Mr. Arar had been returned to Canada from Syria in September 2003. Then Prime Minister Martin asked me to get to the bottom of what had happened to Mr. Arar, and in addition, he asked me to look at whether additional oversight was required for the RCMP in relation to its national security activities. And in fact, that request was in the public documents issued at the time Prime Minister Martin became Prime Minister and the new government was installed on December 13th. Prime Minister Martin and then Foreign Affairs Minister Bill Graham were both very concerned about the conduct of the United States in relation to Mr. Arar. Obviously, that conduct being the deportation of a dual citizen to Syria rather than his expected return to Canada. To try and prevent this from happening again, discussions began with Mr. Graham's counterpart, Colin Powell, to enter into an agreement to ensure that no Canadian holding dual citizenship would be deported to a third country without consultations at the highest levels with DFATE and the State Department. That agreement was adopted by Prime Minister Martin and President Bush on January 13, 2004 in Monterey, and hence its name, the Monterey Protocol. I believe that the original agreement was confirmed recently by Minister Peter MacKay with his U.S. counterpart, Secretary of State Rice. During the early part of January 2004, my department and I considered the best way to fulfill the Prime Minister's request that we get to the bottom of what happened to Mr. Arar. We considered the possibility of the Public Complaints Commission undertaking an investigation, but since there seemed to be some concern as to the scope of the Public Complaints Commission's jurisdiction, we finally decided that a public inquiry chaired by a judge or former judge would be the most transparent and independent process. On January 28, 2004, I announced our government's decision to hold a public inquiry into the actions of Canadian officials as it related to the deportation of Mr. Arar from the U.S. to Syria. I also announced that Mr. Justice Dennis O'Connor of the Ontario Court of Appeal had agreed to serve as a single commissioner. An order in Council was issued on February 5, 2004, officially appointing Mr. Justice O'Connor and setting out the terms of reference. From that point on, it would have been inappropriate for anyone in the government to comment or speculate upon what did or did not happen to Mr. Arar or the reasons therefor. I have read the testimony of my former colleague, Wayne Easter, as well as that of Jim Judd, now Director of CSIS, and that of Commissioner Zaccardelli. I have also read Mr. Justice O'Connor's factual findings and his recommendations. I think that Mr. Justice O'Connor reminds us all of the importance of oversight for the actions of government agencies involved in intelligence gathering and law enforcement. As I mentioned earlier, Prime Minister Martin had called for a review of whether there was sufficient and appropriate oversight of the RCMP in the exercise of its national security role. I know that we all look forward to Mr. Justice O'Connor's second report, in which he will provide us with guidance in relation to additional appropriate oversight mechanisms. And I think in conclusion, let me say, Mr. Chair, members of the committee, that the O'Connor report provides us with insight not only into what can and did happen to one individual, but I think Mr. O'Connor's report, if taken up, and I know that you are taking it up, I know the expressed intention of the government to take up his recommendations. I think if his report is taken up, it will help us again understand the difficulties, the challenges involved in striking the right balance. Obviously, the paradigm foundational responsibility of government is to ensure the collective security of its people. But in doing so, we must always be respectful and mindful of getting the balance right. And I think Mr. Justice O'Connor's report goes some significant distance to providing us guidance in terms of what we need to remember, about that which we need to inform ourselves to ensure that we're always trying to get the balance right. So with that, Mr. Chair, I will conclude my comments and look forward to questions and comments from the committee. Thank you.
Thank you, Ms. McClellan. Appreciate that. And as is the normal practice here, we'll begin with the Liberal Party of Canada. Mr. Mark Holland, please.
Thank you, Mr. Chair. Ms. McClellan, thank you. Thank you for appearing today. Thank you for your words and for establishing the Aurora Inquiry. Wondering if I could start with some questions. The time that you became Minister of Public Safety and Emergency Preparedness, and there would have obviously at that been at that time briefings around the Aurora affair. Can you tell us what the nature of those briefings were, whether or not Commissioner Zaccardelli was included in those, and who might have participated as well from the RCMP in the briefings that took place?
You're quite right that obviously I was the new minister as of December 13th, and we had created a new department as well. So the briefings were comprehensive, as they are when any new minister takes over a ministry. And in my case, we were in the process of establishing a new department and trying to bring some cohesiveness to the various parts of the department from the very beginning. I was briefed by Commissioner Zaccardelli in relation to key issues and challenges confronting the force at the time. I was also briefed by then head of CSIS, Ward Alcock, in relation to the challenges and activities of CSIS. Certainly, keep in mind the time Mr. Arar had returned to Canada in September of 2004. He, upon his return through the months of October and November, had been calling for a public inquiry. Mr. Martin became leader of the Liberal Party of Canada in November 2003. He was being briefed and working through the necessary transition in the lead up to becoming Prime Minister of Canada. So during the months of October and November, there was substantial discussion taking place outside Parliament in relation to Mr. Arar and his situation, and therefore, clearly when Mr. Alcock and Commissioner Zaccardelli came to brief me, the Arar situation was one of many cases, and that we discussed.
At that time, because Commissioner Zaccardelli has testified before this committee that as soon as he found out that there was false information and learned of Mr. Arar's innocence, he informed the government. And we heard from Mr. Easter that there was never, that he had never had any such interaction with Mr. Zaccardelli. Can you tell us that either at the time of those briefings or subsequently, did the Commissioner or the RCMP tell you that they were ruling out Mayor Arar as a terrorist or as an Islamic extremist, either at the times of those briefings or later on? And at any time, did they admit that there had been false information that had been provided to the United States that may have led to the arrest of Mayor Arar?
The first time that I became aware that false information had been provided to the United States was when I read the report of Mr. Justice O'Connor. And I will say that to the best of my knowledge, and I have thought about this because I read obviously Mr. Justice O'Connor's report as well as the comments before this committee of Commissioner Zaccardelli and others. In my presence, Commissioner Zaccardelli nor anyone else, either from the RCMP or CSIS, they never referred to Mr. Arar as an Islamic extremist. That was an expression that was never used in relation to Mr. Arar in my presence, ever.
In your view, in light of what's happened and now seeing Justice O'Connor's report, did the RCMP, in your opinion, withhold information from you at the time when there were leaks and much speculation, including questions in question period from the opposition parties, stating why isn't the government doing more to go after Mr. Arar, why are we being soft on this individual? When those questions were being posed by the then opposition and when the leaks were occurring, do you feel that the RCMP was withholding information from you, looking back on it now, that would have been helpful at that time or the time that you were minister?
I can't say that I believe that the RCMP withheld information from me. I think, obviously, from Mr. Justice O'Connor's report, it is clear that, as I said in my statement, mistakes were made, that information, inaccurate information, was provided to the United States of America, that in some way, in all likelihood, impacted on the treatment of Mr. Arar by the United States of America. I have no evidence whatsoever that the RCMP ever withheld any information from me.
But by the same token, they didn't provide you any information to suggest that Mayor Arar either was or was not a terrorist. So as these leaks are occurring, they're not providing you information the other way. If they're saying that
I think it's fair to say that the only expression that I recall ever being used in relation to Maher Arar by anyone, but in particular the Royal Canadian Mounted Police, was the fact that at least at some point he was a person of interest. I think it's fair to say that that was the expression used by the force.
Now,
or at least, I shouldn't say the force, I should say Commissioner Zaccardelli in relation to any briefing that he may have provided me.
There was an article on October 4th, 2006 in the Toronto Star, and in that article you had said that Maher Arar was obviously a very big issue for the Commissioner. And I'm assuming you mean Commissioner Zaccardelli. Could you expand upon what you meant by that? In what way was this a very big issue for the Commissioner? Was he personally directing this file in your estimation, or what did you mean by that?
That'll probably have to be your...
What I meant by that was that keep in mind that Prime Minister Martin had given me the specific mandate on December 13th to get to the bottom of the Maher Arar case. Prime Minister Martin was also calling for me to review whether additional oversight was required of the force in relation to their national security activities. So I think it's fair to say that the coming together of those two things very much were on the mind of Commissioner Zaccardelli in terms of what mechanism might be put in place to get to the bottom of what happened. Clearly, that would be, the mechanism would be one of interest not only to the Commissioner and the RCMP, but to CSIS and to other agencies within government. So that I would say that in my mind there was no question that the Arar situation, what happened to Mr. Arar, why it happened, and then how we were going to get to the bottom of that was very much front and center for Commissioner Zaccardelli. And I think that my sense of that was that the Commissioner, quite rightly, was concerned, as we would expect someone in his position to be, that he was concerned about what happened. And he was concerned about, the things that Mr. Arar was saying upon his return in relation to what had happened. And I would hope that anyone responsible and head of a force like the RCMP would be concerned and would want to know what happened and make sure that corrective measures were taken so if mistakes were made, they weren't made again.
Thank you very much. We'll now go to the Bloc Québécois. Monsieur Menard, 7 minutes, please.
Bon, je vous remercie, Madame.
Good morning, and thank you, Madam Minister, for the cooperation that you have offered to our committee. I understand that you, when you were appointed Minister of National Security in charge of the RCMP and CSIS, Mr. Arar had already returned to Canada. And so if he had suffered unfair and harsh treatment, that at least was over, and you had really tried to get to the bottom of things, so you took the means that at your disposal to do so. However, you were a member of the cabinet before that time, and I think that the issue concerning Mr. Arar was in the news well before Mr. Martin's new government took power. So during this time, as a member of the cabinet, were you under the impression that Mr. Arar was connected in some way or another to a terrorist group, or were you convinced that Mr. Arar truly was the victim of unjustified treatment?
Question. I think it would be fair to say that at least at various points during that year, from the time he was detained in the United States until his return in September of 2004, that I think the expression I would use is that the impression was left that he was a person of interest. Nobody ever said anything else to me, either before I became Minister of Public Safety, for example, around the cabinet table, in discussions. Nobody ever used the language of Islamic extremist, but I do think it's fair to say that he would have, the impression was that he was a person of interest.
Quel est l'éventail de cas que cette expression?
And what is the scope, the number of people that expression would cover? I mean, would it cover people who are completely innocent, but who would perhaps have been in contact with terrorists, being even unaware that that was so, like people perhaps who are related to terrorist networks, but against whom we have absolutely no definitive evidence?
A scientific term. It is a term of art, and you are well familiar with it, so that a person of interest may very well be completely innocent. And I think that's what Mr. Justice O'Connor concluded in relation to Mr. Arar himself. But it may be, as in Mr. Arar's case, through association with those who are being investigated by whoever it might be. The Royal Canadian Mounted Police, local police, whatever. So that, as you are aware, a person of interest, I think, can bring within it a fairly wide group of people, but person of interest does not, as Mr. Justice O'Connor has indicated, we need to be very careful around the language we use, because you can be a person of interest because of an association and be completely innocent.
Bon, quand vous avez eu une
All right. When you heard Mr. Zaccardelli's statements, when you heard his presentation on Mr. Arar's case, indeed, did he lead you to understand that he thought, in the category of a person of interest, that indeed Mr. Arar was someone who was totally innocent?
again, my impression, now this would come from the briefings I received when I became Minister of Public Safety. The impression, I think it is fair to say, that the impression that was left with me was that Mr. Arar had been a person of interest. I cannot say that as of December 2003, when I became minister, that Commissioner Zaccardelli continued to believe he was a person of interest. I have no reason to believe that the Commissioner in December 2003, January 2004, continued to believe that Mr. Arar was a person of interest. But I think it's fair to say that certainly he and in the briefings with him and others, I had the distinct impression that there had been times in which Mr. Arar had been viewed as a person of interest, and obviously Mr. Justice O'Connor confirms that in his report, that was exactly what Mr. Arar was for a significant period of time.
En tout cas, une chose est certaine, M. Zaccardelli vous a...
Did Commissioner Zaccardelli never speak to you about the wrong information that was communicated to the American authorities? Did he never say that that might have been the cause for his being sent to Syria?
Mr. Holland?
Well,
the first time that I heard that there had been incorrect information provided to the United States of America, authorities in the United States, was when I read Mr. Justice O'Connor's report.
bon. Alors, si...
Therefore, Mr. Zaccardelli left you with the impression that the Americans must have their own reasons to send Mr. Arar to Syria, independently of what the RCMP had said.
We ever specifically discussed that. But if you're asking me, did I believe that the United States, authorities in the United States, must have had their own information and or reasons for deporting Mr. Arar to Syria? Yes. Yes. I think it's fair to say that in my own mind, I presumed that the most persuasive evidence that led to Mr. Arar's deportation was that which the Americans themselves had, not anything provided by Canadians.
Bon. Dans l'optique de la nécessité d'une collaboration.
In light of the fact that there was necessarily cooperation between democratic societies to fight against terrorism, do you find it acceptable that the United States, even if they had their own reasons and suspicions about a Canadian citizen, that they not communicate that information to the RCMP?
I believe that while I know it is somewhat murky, and Mr. Judd and Alcock both, I think, testified, or at least Mr. Judd, to this, one would like to think that if the United States had information in their possession in relation to a Canadian citizen, albeit a dual citizen, that led them to believe that he was involved in some kind of terrorist activity or was associated with known terrorists and so on, that they would convey that information to their counterparts in Canada. That would, to me, be a reasonable expectation.
Okay, thank you.
But it is my understanding from testimony that that did not happen.
All right, thank you very much. We'll now move to the NDP. Mr. Comartin for 7 minutes, please.
Thank you, Mr. Chair. Thank you, Ms. McClellan, for being here. Let me just quickly, because I don't have a lot of time, throughout the entire time that you were minister responsible for this file, you at no time were ever told that any of our intelligence agencies, including the RCMP, had ever used terms describing Mr. Arar as anything but a person of interest. Is that correct?
That's right. And never were the expressions such as Islamic extremist ever used in my presence.
or terrorist, or the one that was floating around in those leaks. There was also one of some kind of a fanatic Islamic or something. Like. Those were the three terminologies that we heard. You never heard any of those. You never got a briefing that indicated to you he was anything in those categories.
I did not.
Here's the difficulty that I have, and I think a lot of Canadian citizens, even those who have maybe just marginally followed this file over the 4 or 5 years from Mr. Arar being deported. Periodically, two things happen. We heard from Americans, Mr. Ashcroft, Mr. Salucci, I'm quite sure, and I think Mr. Ridge, veiled comments. They would never, of course, be forthright enough to say this is what we got from the Canadians, but there were veiled comments that you knew. You, Canada, I don't mean you personally, you, Canada, know, your agencies know why we used rendition against him to send him to Syria. That was in the media repeatedly. I can recall in particular Mr. Salucci, because I've had a discussion with him about it. He said that, and I'm quite sure Mr. Ashcroft did as well. So we had that. And then we had the media leaks, where terms like Islamic extremists were floated. Terrorists was floated, describing Mr. Arar. As the minister during that period of time, and some of those were before you became minister, some were after, did you not question whether that description of Mr. Arar, those allegations, those accusations of Mr. Arar, were coming from our intelligence services? Did you ever ask the RCMP or any of our intelligence services whether they were coming from us? And I have to say, Ms. McClellan, if you didn't, why didn't you?
Certainly, your question has a lot of different components to it, and I may not hit them all, so remind me. The leaks, I was very concerned about the leaks, and there were a number of investigations going on in relation to who was leaking what to whom. And leaks had been an ongoing concern for me, as some of you know, in a number of the portfolios that I held. So leaks were an issue in terms of what was being leaked and by whom. But as you know, we still don't know anything about that, apparently, although there may still be some investigation going on.
Prompts you to ask the RCMP. Is that information that we ever divulged? It just seems to be logical. No, yes, to the Americans.
Well, I knew that the RCMP had exchanged information with the United States. In fact, we have an ongoing information sharing relationship, and Mr. Justice O'Connor indicates how important that relationship is for everyone's shared well-being. So there was no surprise to me that the RCMP and or CSIS would share information with one of our key allies.
It's what they shared, Ms. McClellan. That's the point. You've been told throughout, person of interest. That's what we shared with them.
That's what I was.
Did you, when the leaks were occurring, did you not say, well, wait a minute, is it possible that we did this? It's an obvious question that I would have asked the head of the RCMP. And Mr. Judd and Mr. Elcock.
Well, I guess, as I say, I was concerned about the leaks and whether they thought these leaks were coming from their organizations. Absolutely. And they, I think it's fair to say, probably in a general sense, as much as they could, reassured me that they did not believe the leaks were coming from their organizations.
And what about whether the leaks, whether the substance of the leaks were in fact substantial? Did you question them again at that period of time? Or did Mr. Zaccardelli Commissioner Zaccardelli offer to say in that period of time, this is not information coming from us because this is not true?
No, that was not said to me.
In retrospect, do you not think that's strange?
Well, keep in mind that by the time I became minister, my whole focus was getting to the bottom of this. And the kind of question you just asked would be getting to the part of getting to the bottom of this. And getting to the bottom of it, we knew that that was not going to happen because of so many things that had transpired. That was not going to happen simply by me or the government or PCO asking questions of various agencies. That was only going to happen by some kind of independent review. So my focus was on the fact that we had a whole bunch of questions here that we didn't know the answer to, and as every day went by, it was getting murkier and murkier, and in part because of the leaks, and that the only way we were going to get to the bottom of this was to have some kind of independent mechanism.
Okay, but when Mr. Cellucci in public would say, veiled always, this information, Canada knows this information, why we used rendition against Mr. Arar, would you not at that point go back to Mr.
Although, in fact, I believe it was, if I remember discussions generally at that time, when those comments were made, the Minister of Foreign Affairs, who I believe was Bill Graham at the time, Mr. Graham, I think, reacted quite strongly to Mr. Cellucci's comments because my sense was that he rejected what Mr. Cellucci had said in terms of the fact that if what Mr. Cellucci meant was that we were somehow complicitous in Mr. Arar's deportation. And I think Mr. Graham generally tried to clarify for himself and for the government and for others that no, we were not involved in Mr. Arar's deportation.
Your final little brief question.
Based on the information he was getting from the RCMP, which in fact was not accurate. Because they had, in fact, given the customs people in the United States, in the customs report, allegations that Mr. Arar was more than a person of interest.
I think it's quite clear from Mr. Justice O'Connor's report that incorrect information was provided by the RCMP to authorities in the United States. I did not know that at the time. And I would have no reason to ask, in the sense that I would have expected that the RCMP and any government agency would follow their normal protocols and normal methods of procedure. And it was only when I read Mr. Justice O'Connor that it became apparent to me that, in fact, the normal procedures around the exchange of information and the imposition of caveats had not been followed. But I would have had no reason to ask that at the time, because one presumes that, in fact, the rules are there, the guidelines are there.
You had the media leaks, and you had those statements made by the other ministers from the other country.
Yeah.
Would that not have prompted you to ask the question at that point?
We'll have to move over to the Conservative Party if they wish to pursue this. They may do so. Mr. Brown for 7 minutes.
Thank you, Mr. Chairman, and welcome back to Parliament Hill, Ms. McClellan. Good to see you again. Today's testimony really leads to more questions, and the one thing that, and I sense from being on this committee and hearing from the witnesses, a real sense of frustration that we're really not getting any answers, and in fact, what we're getting is leading to more questions. But one thing that you said was that you believed that the Americans sent Mr. Arar to Syria based on their own information. And in fact, you're the first one that's been quite clear on that. If that's the case, why do you believe the Government of Canada owes Mr. Arar an apology and could be on the hook for up to $400 million?
Well, first of all, it's my assumption. It was always my assumption that the United States must have had some information of its own. Now, I could be wrong in that assumption. I don't know. And, of course, none of us know, because part of the problem was that the U.S. decided not to cooperate with Mr. Justice O'Connor's inquiry. So it was my assumption that you would not take a Canadian citizen, albeit a dual citizen, and send them to a third country unless you had some persuasive reason for so doing. And I assume that the United States would have its own independent evidence to that as to why they would do that. But I could have been wrong in that assumption.
Okay. Now, we know you took up your duties with public safety and emergency preparedness in December of 2003, which was right after Mr. Arar came back to Canada, and he had his media conference where he advised us that he had been tortured. And he suspected rightly that there was Canadian complicity in the fact that he was sent there. So I take it as a member of cabinet at the time that you were aware of the case before you became the minister, and that after becoming the minister responsible for the RCMP, that you checked into it and saw that they may have supplied some inaccurate information to the Americans about him. So this going back to my original question. So were you aware, for example, of your government's efforts to seek his release and the attempted one-voice letter?
Pardon me? Sorry, I couldn't hear you.
Oh, I'm sorry. Were you aware, for example, of your government's efforts to seek his release and the attempted one-voice letter at the time?
I think I was probably aware of the activities. Keep in mind I was Minister of Health, but I think that probably there were, at Cabinet, at various points, if my memory serves me correctly, Mr. Graham would provide a general review of a host of issues, and I think that it was quite clear we were very concerned about his deportation, and in fact, as I mentioned in my opening comments, Mr. Graham was so concerned about that the U.S. would deport a Canadian citizen to a third country that he immediately set about working with Colin Powell to reach an agreement by which we would hope that wouldn't happen again. So yes, if you're asking was I generally aware that before I became Minister of Public Safety, that there was an attempt to reassure or to make sure the Syrians understood that we wanted Mr. Arar returned? Yes, and I think that was generally discussed.
Well, let's move on to when you were first appointed minister. Now, Margaret Bloodworth, she was your deputy minister at the time from the outset, and
at the time,
she was your deputy minister when you became
as of
minister?
December 13th.
And was
yes,
she
03.
your deputy throughout your term in
yes.
that portfolio? And okay, so now I presume that you'd agree with me that Ms. Bloodworth is one of Ottawa's most experienced civil servants, and that as minister that you relied on her knowledge and accurate and timely and relevant information on all of the subjects, including things such as the gun registry issues and, of course, the Arar issues. Is that right?
Well, she was my deputy, and therefore she was involved in all the key issues and files in the department. For example, after our decision to go to a public inquiry, she worked very closely with then Deputy Minister of Justice Maurice Rosenberg and Rob Wright, who was National Security Advisor, to determine the terms of reference for Mr. Justice O'Connor and so on.
Okay. Can you tell us about the last time that you spoke with Ms. Bloodworth? When was the last time you spoke to her?
In an official capacity, when I left.
Period. When was the last time you spoke to her? Have you spoken with her since the O'Connor report was released?
I talked to her briefly, but not in relation to this matter. Okay. Something entirely different.
Okay. How are we time-wise?
You've got about 2 minutes.
Okay. When you were first appointed, you had a series of briefings, did you not, from your departmental officials, including Ms. Bloodworth, is that right?
I had a series of briefings, yes.
Okay.
My deputy was not in all of the briefings, but she certainly would have attended a considerable number of them.
So, and you also heard from Commissioner Zaccardelli, is that
yes.
right? The director of CSIS.
Yes.
So given the profile of this Arar case, and what we now know to have been a PCO briefing where there was some discrepancies on the subject, I presume that those briefings included both the case itself and the PCO briefings, is that right?
I received no briefing in relation to a PCO briefing,
okay.
Nor would I. There'd be no reason why I would know anything about that.
Okay. Did you ever meet privately with the commissioner or director of CSIS?
Yes. I mean, privately, my chief of staff would be present. Margaret might be present. Rob Wright might be present. But yes.
Was Ms. Bloodworth always present?
No, I do not think she was always present.
Okay. Now, I'm having a little bit of trouble believing that is the minister responsible for what was at that time a hugely public security case, that it wouldn't dawn on you to ask these questions of these people. Well, if you know, in this passive role, you didn't seem to ask the questions about the case that you're hearing from all of these people. This is a case that could cost the taxpayers of Canada up to $400 million at this point. Maybe you didn't expect that to be the case at the time, but you became the minister. It was at the time of the leaks. All of these things were happening, and you weren't asking all these
I
questions?
became minister, and my focus was getting to the bottom of it. We knew that the questions were growing, and my obligation at the request of the Prime Minister was to get to the bottom of this matter, hence the O'Connor inquiry. And in fact, I believe more so now than ever that was the responsible course of action, because now all Canadians understand what happened, and that was my focus. We knew that things had happened that had raised serious questions. Those questions were being raised by Mr. Arar and his own lawyer, being raised by the press and others. And my goal was to find out, put in place a mechanism by which we could all get the facts. So the rumor and the innuendo and the leaks would hopefully stop, and we would actually have an independent, credible third party be able to tell all of us what happened and why. That was my focus.
Okay, we'll have to wrap it up. Thank you. We'll now begin the next round of questioning, 5-minute questions. Mr. Cockler, please.
Thank you, Mr. Chairman. You had mentioned that you had been advised regarding Maher Arar that he was a quote-unquote person of interest. My question is, do you not believe that a Minister of Public Security in a post-9/11 universe, whoever that minister would be, should have been advised that the RCMP considered Maher Arar or any other person that they might have had such views of was an Islamic extremist associated with Al-Qaeda? Should not that be the kind of information that would be normally conveyed to a Minister of Public Security?
Well, one would presume so, that in fact, if one believed that someone was an Islamic extremist with Al-Qaeda connections, that is indeed the kind of thing that a Minister of Public Safety should know and should be informed of. And as I said earlier, to the best of my recollection, Maher Arar was never described in those terms by anyone to me.
Let me just put the same question in another context. Is it not somewhat strange that that information, which ought, in my view, to have been conveyed to whoever would be the Minister of Public Security in Canada, would have been conveyed to an American official while not being conveyed to a Canadian Minister of Public Security?
Well, I don't know, and quite truthfully, while I read Mr. Easter's testimony, I do not remember whether you asked him and what his answer was in terms of whether he ever received information that described Maher Arar in those terms. All I know is that I didn't receive such information. But if at some point the RCMP or CSIS believed someone to be an Islamic extremist with Al-Qaeda connections, one would presume that that information would be conveyed to, at a minimum, the Minister of Public Safety.
And at a minimum, would it not be the case that the Minister of Public Security would also have then to have been advised that that information was false and misleading? To put it another way, why should the U.S. authorities have then had that false and misleading information corrected, but Canadians, the Canadian Minister of Public Security never had that corrected while the Commission of Inquiry was set up, or even before that? I'll put it to you another way. Would it not have been something that, as the Minister of Public Security, you ought to have known, the government ought to have known, in order to determine whether a Commission of Public Inquiry was the appropriate mechanism or some other mechanism?
I agree with that it would have been useful information to have from the force that, or whoever, that a mistake had been made and that incorrect information had been conveyed to authorities in the United States in relation to Maher Arar, and that I think my own view would be that that would lead to another set of issues that might very well lead to a public inquiry or become part and parcel of a public inquiry, which is in relation to how could that mistake have been made? Why was it made? And what are the procedures that should have been followed that weren't? Do we need new procedures? Do we need oversight mechanisms? But yes, I take your point that if some within the RCMP believed that false information had been provided to the Americans, that as Minister of Public Safety, I would have expected to have been told that if they understood that they had provided false information.
And as Minister of Public Safety, would you not have considered it appropriate, or in another way, inappropriate, for you not to have been advised, nor anyone to have been advised, during the entire time of the Commission of Inquiry, while misleading leaks continued to come out, that Maher Arar, in fact, was not what had initially been said of him and continued to be said of him. In other words, that the public record was never corrected by the RCMP during the entire time that this information had been conveyed to the U.S., then corrected in the U.S., but the public record in Canada had never been corrected.
Okay, that'll have to be your final question.
Yeah, that is my final question.
Thank you.
I think I would say this, that I think once Mr. Justice O'Connor was put in place, it does not surprise me that those who were going to testify and be subject of his investigation would not outside the inquiry offer gratuitous comments. I would personally find that inappropriate. Mr. Justice O'Connor was in place. He was investigating this matter. He was going to hear testimony from the RCMP, from CSIS, and so on, and that's why he was put in place, to be able to bring everything together in one place and make, we hope, definitive conclusions around who knew what when and what was said by whom and what the consequences of that were. I agree that up until the appointment of Mr. Justice O'Connor and the decision to have the inquiry, that if the RCMP knew that Maher Arar had been misdescribed at any time, and in their opinion was an innocent person, it would have been, I think, useful, if not expected, that they would so convey publicly.
Okay, thank you. Monsieur Menard, 5 minutes.
Thank you again, Madam Minister, for cooperating with us. I would like to say that you took the right decisions at the time that you were given responsibility for this issue. But I understand from what you're saying that you would have greatly preferred that the United States accept to cooperate with Judge O'Connor.
I think that that is the key piece that is missing.
Okay. Parce que là, il y a quand même une chose que vous saviez tous.
Because in the meantime, there is one thing we all are aware of. We have relationships with Syria, but we are perfectly aware of the fact that their methods for interrogating people and the techniques they use.
A fair assessment. Based on a number of different pieces of information, including the fact-finding report done by, at the request of Mr. Justice O'Connor, by now President of UBC, Stephen Toop.
Alors, envoyer un citoyen.
So, to send a citizen to Syrian jails is a very serious act that could perhaps be justified by very, very serious suspicions related to terrorist activities. Yes, is that correct?
I would have to say that the return of anyone, if I were a Canadian government official and we were seeking to remove someone from this country and return them to Syria, I would be very concerned about that because we have, of course, signed the convention that speaks to the Convention Against Torture and Other Cruel and Inhumane Treatments. And I would think that it would be based on what we know of Syrian activities. I would be very concerned in relation to the deportation or return of someone to Syria if they asserted that they were likely to be tortured. Bottom line, yes, I think that we as a country need to be concerned in terms of where we send Canadians or others if we have reasonable suspicion of torture or other inhumane acts.
Alors, on sait toujours.
So we still don't know why the Americans sent Mr. Arar to Syria, so we're obliged to speculate on two things. Either it is because of the incorrect information that was given to them by the RCMP, or it's following information that they themselves had that indicated to them that Mr. Arar, that they had serious grounds on which to believe that Mr. Arar was connected to some kind of terrorist movement. But if they had such reasons of their own, it is unacceptable that the Americans did not communicate those reasons to the Canadian authorities, because with the exchange of information that we have between these two countries, both fighting against terrorism, that if we have information on the other country's citizen before deporting him to Syria, that information be shared, and we still don't know it.
Principle that information should be shared, and I would go even further and say that I would be most concerned if they chose not to share that information. I think that would be something that a prime minister would take up with a president, or someone in my position would take up with a John Ashcroft or a Tom Ridge, or whatever the case would be, if we believed that they had such information and they were not willing to share it with their counterpart organizations in Canada.
Maintenant, à l'époque où vous étiez simplement ministre.
Now, at the time that you were a minister, just a minister, had you known at the cabinet table that the head of the RCMP believed, was convinced that Mr. Arar was completely innocent of any relationship with a terrorist group, do you believe that the government's reaction would have been different to try and free him from Syrian authorities?
Made all reasonable efforts to free Mr. Arar from Syria, and I think Mr. Justice O'Connor makes that point quite clearly in his report. He does not really criticize the Canadian government and our consular officials and others, or the Minister of Foreign Affairs, in terms of the actions they took to try and get Mr. Arar out of Syria. I think Mr. Justice O'Connor talks about the fact that he had some concerns around the one-voice letter and what happened or didn't happen, but overall he felt that the Canadian government discharged its obligations and responsibilities in relation to getting Mr. Arar out of Syria and letting the Syrians know we wanted him back, and in fact the Prime Minister of the day, Prime Minister Chrétien, wrote such a letter to the Syrians. But we didn't, in a sense, even need some kind of statement from the RCMP that Mr. Arar was completely innocent. What we wanted was Mr. Arar, as a Canadian citizen, out of Syria and back in this country. Because we believed that it was singularly inappropriate for the United States to deport a Canadian citizen to a third country without even consulting Canada about that deportation. So we wanted him back.
Thank you. Thank you. We'll have to move to the final questioner for this round. Mr. Hahn, for 5 minutes, please.
Thank you, Mr. Chair, and Ms. McClellan, good to see you again. Before I get on to a couple of questions, I just want to echo the incredulity across the way at the lack of curiosity of a Minister of Public Safety that, given the information that was in the public domain available to 32 million people, that suggested that Maher Arar may have been something beyond a person of interest, that that there wouldn't have been more probing from your part. But I want to follow up a little bit on Mr. Brown's questions. Were you ever told by the RCMP or your deputy that the information supplied to PCO was inaccurate or incomplete?
No.
Did you ever speak with people at the PCO about the Arar case in your time as minister? And did those, if you did those people include Rob Wright and Bill Elliott?
Rob Wright, certainly. Bill Elliott, I'm not so sure about, but certainly Rob Wright.
Okay.
He was National Security Advisor to the Prime Minister.
Were you provided with information about that PCO brief, including its actual content, or whether the department had been advised?
I never knew that that some kind of briefing note had been provided to PCO. I mean, PCO receives briefing notes, dozens of them every day from different agencies and organizations in government. I would not necessarily be made aware of any particular briefing note.
Okay. Given your ministerial responsibilities, do you agree or not that this is information that you should have been provided, whether from the RCMP, CSIS, or your department, if they were aware that the RCMP briefing to the PCO was inaccurate or incomplete, and should they not have spoken up if they knew that?
Well, I suppose if at some point the RCMP knew that they had sent a briefing note to PCO that was incomplete or erroneous, that they should have corrected that, certainly with PCO. Whether I would know that or not, or whether I should, it would not be something that's necessarily germane, because the RCMP provided, as I say, briefing notes, as did CSIS and others, to PCO at PCO's request, which is perfectly normal.
Given the profile of the Arar case, if they knew that there was something amiss, don't you think that they would have had a responsibility to tell you, or wouldn't you not have expected that?
The clerk of the Privy Council and anyone who requested that note, absolutely. But I believe that note was provided to PCO before I became minister, I think, based on the timelines, but I'm not sure about that.
Well, Commissioner Zaccardelli has told this committee that he personally learned of the RCMP errors in November of 2002, and that he thereafter, this is November 2002, briefed ministers and officials about what he had supposedly learned. Now, Mr. Elcock, Mr. Easter, and you deny hearing this, and I know you weren't minister at the time. I think it's appropriate, and I'd ask your opinion, do you think we should be calling Ms. Bloodworth to testify before this committee because there's a collective lack of memory or something more deliberate, perhaps, at the highest levels of the Canadian security bureaucracy, which thankfully Justice O'Connor has exposed?
Well, it's up to the committee to determine whether you want to call Margaret Bloodworth. I mean, clearly, she was my deputy from December 13th, 03 forward, after Mr. Arar returned to this country. I'm not sure. I think she was Deputy Minister of National Defence before that. I'm not sure what direct information she would have in relation to the Arar situation, but certainly, if one felt that she had useful information, I'm sure that you could call her.
Because clearly we've got three now ministers, I think, on one side, and one commissioner on the other side in terms of who knew what.
And I know that you're going to call Commissioner Zaccardelli back, at least that's my understanding, and I think probably my thought would be that he may very well clarify some of his comments as to what he knew when. I can only testify as to what I knew when, and the first time I knew that the RCMP had provided inaccurate information to the United States was when I read Mr. Justice O'Connor's report.
And given all the information in the public before that, it never sparked your curiosity to be more forceful with people that your departments that your department was responsible for, to ask?
Oh, well, we were concerned about leaks, as I said. But in terms of why would I assume that the RCMP would not follow their normal operating principles in relation to the provision of information to the United States? So there were protocols in place, there were caveats. That was part of the normal operating procedure. There's no reason to presume in my mind that the RCMP would not have followed normal procedures. By the time I became minister, there was sufficient concern and murkiness around certain things, especially comments made by Mr. Arar as to his treatment, that the then Prime Minister said, "Anne, I want us to get to the bottom of this." I immediately began to work toward a process by which we got to the bottom of this. That, of course, within 2 months, led to the appointment of Mr. Justice O'Connor, which within the Government of Canada, as you're probably learning, is virtually lightning speed.
Final question.
And I applaud you for that. Just a quick final one then. Given that there are so many questions unanswered, and I frankly doubt that we'll ever get much satisfaction on this, do you think, what's your view of a parliamentary oversight committee to oversee the operation of the Canadian security services?
I introduced legislation. I introduced legislation to that effect, and Monsieur Menard, Mr. Comartin, my colleague, former colleague Erwin Kotler, all worked very hard, as did Mr. Sorensen and others, in relation to the creation of such a committee. And I introduced legislation just before we were defeated in the House last November, painful an event as that was. I introduced legislation last year, which I think, while there was not unanimous agreement as to all aspects of it, and Mr. Comartin might speak to this, or Mr. Menard, I think we worked conscientiously in an all-party fashion, House of Commons and Senate, to put forward a piece of legislation creating a parliamentary oversight mechanism similar to that in the United Kingdom, where you would have parliamentarians come together in a nonpartisan way, because national security is not a partisan issue, and you in fact create an all-party committee where the members of which take a special oath so they have access to sensitive information, and they work in such a way that they are able to provide an additional and I think important degree of oversight in relation to national security agencies and activities.
Thank you. We'll now go to our third round.
I share your pain.
No, I didn't expect you to. Sorry.
Anyway, thank you. We very much appreciate your attitude towards that. Anyway, thank you. Mr. Alghabra, for 5 minutes, please.
Thank you, Mr. Chair, and good morning, Ms. McClellan. Good to see you again. First, I want to go back to a point that was mentioned earlier, and particularly by Mr. Brown, and you brought up the fact that, yes, there is a possibility that the Americans had other information that led them to the deportation of Mr. Arar to Syria. But I want to make it very clear, and I want to see if you agree with me, that there's no dispute. It's indisputable that the RCMP had sent misleading information to the American authorities, and that I think it's very difficult to argue that it did not contribute to the deportation of Mr. Arar to Syria. Is that a factual statement?
I agree entirely with the conclusions of Mr. Justice O'Connor in that matter, and I think you've just summarized them.
So whether the Americans had any other sources of information or not might be relevant to try to understand what the Americans did, what they did, but it's still within our mandate, our responsibility, the fact that the RCMP had broken protocols. Absolutely. And sent misleading information.
Absolutely. That is what Mr. Justice O'Connor concluded.
And I don't think there's, that fact is being disputed, especially after Judge O'Connor's report. And what I find interesting is that all the three former ministers, including yourselves, have told us that none of that information was shared with the ministers by the RCMP. None of the fact that the information that was given to the United States authorities that was misleading, the misleading information was being shared with the ministers.
We were not, I can only speak for myself, but I was not aware that inaccurate information was provided by the RCMP to the Americans. I knew that information had been provided. I did not, and that would be perfectly normal. I did not know that there was inaccurate information that had been provided.
At the time, you probably wouldn't have known if it was inaccurate or accurate, but were you told exactly what the information was that was shared with the American authorities?
I'm sure, in a general sense, when I was briefed by the commissioner and others in terms when I became Minister of Public Safety, I do not remember precise details, but I am sure that in a general sense, I was told of concerns in relation to Mr. Arar being a person of interest, and I think I would have been told the fact that there were others. For example, as Mr. Justice O'Connor points out in his testimony, that the reason it appears Mr. Arar was a person of interest was because of some of his associations, and I think that that general factual context was provided to me.
But we know now that the RCMP had part of the information that they had given the American authorities was that they considered Mr. Arar as an Islamic extremist.
That was an expression never used in my presence.
But now you tell us that it wasn't. So there's obviously a disconnect between what information the RCMP had given the American authorities and what they had given the ministers, particularly you.
Yeah. All I can say is that I do not, to the best of my recollection, ever remember being told that Mr. Arar was an Islamic extremist.
Well, now that you know that, what is your opinion of that disconnect? How do you categorize, or what would you consider that behavior? Was that incompetence? Is that deliberate misleading of minister?
I think, as Mr. Justice O'Connor determines, there was no deliberate intent here to deceive. There was no complicity on the part of Canadian officials in Mr. Arar's deportation to Syria. Mr. Justice O'Connor is very clear about that. I think mistakes were made, as I said in my opening statement. He's clear about that. There were normal processes that anyone, including any minister and any Canadian, would have the right to expect the RCMP would follow. There is a serious question, which I think Mr. Justice O'Connor addresses as really the heart of the matter in some respects, which is the processes were in place. He finds that conclusion. Why weren't they followed? And he offers us some of his views on why they were not followed.
A brief one.
Yeah. Who do you think someone should be held accountable? And if so, who do you think should be held accountable?
You know, obviously in government, accountability, transparency, and accountability are very important. That's why we asked Mr. Justice O'Connor to do what he did. If mistakes are made, then there has to be accountability for those mistakes. I'm not suggesting that accountability, and I don't think we should live in a world where accountability always means that someone gets fired. I think that, in fact, that's a very immature view of accountability. In some cases, it may mean that someone gets fired, and fair enough. In other cases, it may mean something else. It may mean that you change the procedures that you had in place that led to the mistake to make sure that it doesn't happen again. And it's my understanding that that's in fact what the force has done. And Commissioner Zaccardelli testified to that effect, that he has taken up the recommendations of O'Connor in terms of centralizing a clearinghouse for the sharing of information, both domestic and foreign, and so on. And so that I think accountability is key. I think accountability takes very many forms, and we have to get past the notion that heads must roll to have accountability. Sometimes maybe they should. In other cases, it will be something else, and perhaps more important in terms of the culture of that organization.
Thank you very much, and we'll now go over to the government side. Mr. McKenzie.
Thank you, Chair, and thank you, Ms. McClellan, for being here. I guess I have some serious concerns about the whole focus seems to be to blame officials for whatever went wrong. And I would suggest to you, and I think you would probably concur, that in your role and the Cabinet's role in government is to provide governance to those agencies that report upwards to us, right? Well, that was going on. Obviously, there was a lot of press, and there must have been some discussion within Cabinet. I look to my friend Mr. Kotler across the table. He's a learned individual. He was the Minister of Justice. You had lots of people around that table that would have raised and could have raised questions and provided questions to you that should have gone back down to the officials that we're now criticizing. Did that ever occur?
Oh, there were discussions at Cabinet, general discussions, as I say. The Minister of Foreign Affairs, Bill Graham, would update colleagues in terms of a wide range of issues, and clearly there was concern around how Mr. Arar ended up in Syria and the efforts being made to get him back. But keep in mind, when I became minister, I was given a clear mandate from Prime Minister Martin. I want you to get to the bottom of what happened. We immediately set about determining the best process to put in place by which to get to the bottom of the matter. And I'm very proud to say that we put Mr. Justice O'Connor in place, and I believe we got to the bottom of this matter to the greatest extent possible.
Well, I wouldn't want to debate that issue, but it would seem to me that the position you were in, given that the press were reporting what they were reporting, whether it was accurate or factual or not, and issues surrounding the leaks and all of the concerns that we're now hearing, and somewhat of the indignant, approach that has been taken towards the authorities that were, RCMP, CSIS, and others, that no one was saying, Minister, you've got to ask the Commissioner, you've got to ask these people. Where are the leaks? And is there any truth to these matters? And what do we need to do to go forward without, getting into the areas that Mr. O'Connor ultimately got into? But in that whole time frame, there had to be questions that were coming forward. I just...
Serious questions about the leaks. In fact, that's why investigations were begun. I believe PCO began one, the RCMP began one, CSIS began one, into the leaks. And in fact, that's, as I say, that was a concern of mine. Where are these leaks coming from? Because in fact, these leaks could be very damaging to Mr. Arar. They could be very damaging to the credibility of our law enforcement and intelligence agencies. So that's why those investigations were begun. But at the end of the day, I think by the time Mr. Martin became Prime Minister and I became Minister of Public Safety, we had determined that there was sufficient murkiness in terms of the stuff that was in the papers, the fact that people couldn't find out.
But did we ask those officials what information they had passed to the Americans? Because that seems to be the crucial issue, is if nobody ever asked what information they passed, how could we make decisions on whether or not the Americans acted on our information or they acted on information that they already held?
As far as I remember, in the briefings I had, clearly, I was told that information was shared and that information was in relation to Mr. Arar. As I say, however, to the best of my remembrance, he was never described as an Islamic extremist to me.
But that's a briefing. Did you ask the question? Did we?
Why would I ask how? Did you describe Mr. Arar as an Islamic extremist? No, I wouldn't.
What information did we pass to the Americans? That's the simple question.
We in fact talked about the information that was provided to the United States. The problem here is, of course, that it was only later in Mr. Justice O'Connor's report that it came to my attention that there had been inaccurate information provided. Because by the time I became minister, nobody was describing Arar, and Mr. O'Connor documents this as an Islamic extremist. Because based on what Mr. Justice O'Connor discovered, they corrected the information. So nobody was describing him as an extremist to me.
But I think my friend is suggesting the RCMP considered him an Islamic extremist.
Point, but as Mr. Justice O'Connor points out, that information was corrected.
Do we know if that information ever went to the Americans from the Canadian side? Did our officials describe him to the Americans?
What I know is what Mr. Justice O'Connor, who had the opportunity to bring together everybody involved in this piece and hear from everybody, both in public and in camera. And therefore, I think Mr. Justice O'Connor tells us and provides us with the best information in relation to that which was conveyed to the United States.
Okay, you'll have to wrap it up. Okay, thank you. Back to the Liberal side, Mr. Holland, please.
Thank you, Mr. Chair. I think the issue is one, in fairness, you can't answer. I think that's part of the problem, and we're kind of belaboring the point. But I think the problem is that there is deep concern with the fact that the RCMP would have sent information to the United States that indicated that Mayor Arar was an Islamic extremist and potentially a terrorist. They would have sent that information to the United States. And the fact that they then would not have shared that with yourself or with Mr. Easter before you or with other government officials. That's the concern. And so I think what you're telling us is that they didn't, and all evidence backs that up. And I think that's the concern of committee members, and I don't think you probably can answer a lot more on that, other than it leaves some very disturbing questions about why that occurred. I'm wondering if we can go back to the issue of oversight for a second. And if you could talk about, in the wake of this, I mean, there were two actions that were taken. One was to establish the Commission of Inquiry, to have Justice O'Connor look at this and prepare his reports in 2 phases, as he's doing. And the second item related to oversight and ensuring Parliament had a greater role. Can you elaborate upon that a little bit and talk about what other actions were taken in terms of the oversight of security and intelligence, and specifically the RCMP?
Well, as I mentioned in my comments, when I became minister, I was given the specific mandate to look at whether additional oversight was required for the RCMP and its role as it related to national security. And I took that challenge up, and as we worked through how we might go about determining what additional oversight might be required, it became apparent that the best person in all likelihood to offer us advice would be Mr. Justice O'Connor, because he would have worked through a specific example, potentially, where oversight may have been lacking, for example, so that we thought it made an awful lot of sense to give Mr. Justice O'Connor not only the factual Arar inquiry, but then flowing from that, and in more general terms, provide us with his expert knowledge in terms of what additional oversight was required. It's quite clear, although we don't have his second report, that he will recommend an independent review oversight mechanism of some sort. We looked at, for example, the Public Complaints Commission exists, but my own view is that as presently constituted with its present mandate, it has neither really the mandate nor the resources to do what is required in terms of additional oversight as it relates to RCMP activities in the area of national security. So whether you increase its mandate and give it more resources, or whether you create an independent body, I think it's pretty clear that Mr. Justice O'Connor talks about an independent review body. I presume he means not the Public Complaints Commission, but some additional body. If we look at SERC, I think SERC has worked generally well for CSIS. And SERC is an aggressive body that takes its mandate seriously, that is well-resourced to do what it does, and I think has developed substantial credibility, not only here but abroad, in terms of providing oversight for the activities of CSIS. I would think, based on what I've read of O'Connor so far, he talks about an independent review mechanism. I think that's probably the way he is going to go, although we all await that. I would agree with that. I think that in the area of national security, it is there, as he says, the lines blur a little bit as hard as one tries to prevent it from happening. The lines blur between that which is intelligence gathering and that which is traditional criminal investigation and law enforcement. And so consequently, I think an oversight mechanism in relation to those activities which are fairly described as being of a nature regarding national security does make sense for the Royal Canadian Mounted Police. Leave the Public Complaints Commission to deal with oversight and review as it relates to traditional criminal investigations and law enforcement. Create an additional body, in all likelihood, for oversight as it relates to national security.
Final question.
The next issue for me in looking at this is that we had 3 separate bodies with different pieces of intelligence that chose to share that intelligence in different ways, both with the government and with other agencies. In the example of the RCMP, they seem to have shared certain information with the government, certain information with CSIS, certain information with foreign governments, whether or not it's the United States, or the information that they got from CSIS or from the government. How do we reconcile this? I mean, because obviously we have a real problem here, where you have three different bodies with different points of view on the intelligence that's before them, different ways of using that intelligence. I mean, do you think it speaks for the need to have one vehicle through which intelligence is collected and vetted? And secondly, what about rules around information that comes from states that are known to practice torture? And the fact that the RCMP and CSIS, when looking at that information, particularly CSIS, made an assessment that torture wasn't involved, and yet the person making that assessment had no experience in torture. I mean, how do we get past some of those things, and do you have any thoughts on it?
Well, first of all, as it relates to the receipt of information for countries where we have a reasonable suspicion to believe that they use practices such as torture, I think as Mr. Judd testified, one needs to be very careful about that information, and one should be. I would not say that one necessarily never uses that information, but I would say that you shouldn't use that information unless it is corroborated by other sources that you believe, where in fact the corroboration comes from information not derived, or you at least have a reasonable suspicion that it was not derived from a product of torture. So I think corroboration is key if you have a suspicion that there is any intelligence or information you've received that came from the product of torture. In terms of intelligence, I don't think you can have one agency collecting intelligence. I mean, intelligence is gathered in the world in which we live by intelligence gathering agencies like CSIS, the RCMP, the Department of Transport, the Department of Foreign Affairs, the Department of Immigration, and so on, international trade. They all collect information or intelligence of one sort or another. What you need to do is, I think what we did, which the British have done, the U.S. is now working toward, which is some kind of integrated threat assessment body where all that intelligence comes together in one place, and you have your key analysts from all those departments, senior people, working together. All the information is on the table. It is shared, and it is analyzed, and then it goes back to the front lines to hopefully, in real time, to be able to prevent, for example, high-risk individuals entering the country or being able to cause harm or whatever the case is. And hence the fact that we created an integrated threat assessment center to bring all that intelligence together. I think key intelligence gathering agencies have to have oversight. CSIS has CERC. I believe we will see what Mr. Justice O'Connor has to say about what should exist for the RCMP. I believe there should be an oversight committee, ultimately, of parliamentarians that can actually, again, sit on top of all of this in a sense. If you've got some concern about how DND is collecting and using intelligence, or whether they're not sharing it with our integrated threat assessment center, you as parliamentarians should be bringing people before you and getting to the roots of the matter in terms of what's happening, who's putting what on the table, are people holding back, are people protecting turf? If so, that could endanger the well-being of Canadians, and you as parliamentarians need to know that. And I think that's one of the roles an oversight committee could play, an oversight committee of parliamentarians.
Thank you, Ms. McClellan. You obviously are a teacher and a professor, and you make sure that we get the complete, full answer where there's no loose ends. Thank you.
I'm sorry.
But I want to just follow up on this. Was the O'Connor Commission ever instructed to give us feedback on whether there should be parliamentary oversight? Like you're just talking about the Parliament. Did you ask him to do anything in that respect?
No, that was not a specific question.
Why not?
Well, because we asked him to look at the specific question of whether there was additional oversight required for the RCMP as it related to their national security activities. Now, Mr. Justice O'Connor may, I don't know, I haven't seen his report, he may talk about the importance of parliamentary oversight as part of his answer to the question. We kept the question very general. What do you think would be appropriate oversight for the force as it related to national security matters? He has tipped his hand, in a sense, in the first part of his report by saying he believes an independent review mechanism is important for the RCMP. He may, in fact, go further, I don't know, Mr. Chair, and talk about the importance of parliamentary oversight and the fact that that would be a complementary cap to any kind of independent review mechanism that he might suggest. Certainly, there's nothing that precludes him from talking about parliamentary oversight in his second report.
Okay. Thank you. Okay. Everyone has had at least an opportunity to ask questions in this first round. Does anyone else have any other questions to pose before we wrap this up? Everybody's had one opportunity. We'll go to the Liberal side here, Mr. Algabra. Are you going to?
Not
or Mr. Kotler?
Yeah.
Which one of you will it be?
It's not a question. I just want Mr. McKenzie kindly made reference to the fact as to whether the Meher could have been discussed with some other people around the cabinet table like myself. I think I just, for the record, need to mention that I recused myself in all matters relating to Meher because I had acted as a counsel for his family prior to my being appointed to the cabinet, and consequent upon the establishment of the commission, something that I had otherwise recommended, I then immediately desisted and was not in the room when any discussion. I left the cabinet room whenever any discussion might have taken place relating directly or indirectly to Mr. Arar.
Thank you. Mr. Algabra, you have some brief questions?
Sure. Thank you, Mr. Chair. I want to go back to the discussion that you and I had about accountability. And I want to agree with you that I don't necessarily think, although maybe some people do, that the definition of accountability is rolling heads. There are many measures. And I think it's also good that we examine our protocols and see if we need to strengthen them. But the reality is that the existing protocols were broken. So there were protocols that were broken. Therefore, I think while we do want to examine how we can make sure our protocols are foolproof and more friendly, but how do we deal with the fact that we know the rules were broken, in your opinion?
Well, I think you need to hold people account for the fact that rules were broken. And as I said, there are different ways one does that. And it will be up to the government of the day to decide whether they believe accountability in this context requires that anyone, be relieved of their official functions. But I do think that one of the key ways we make sure that these kinds of things don't happen again is to review the protocols, the basis on which we share information, the countries with whom we have agreements, whether the terms of those agreements are satisfactory, especially with countries where we have a reasonable apprehension or suspicion that they practice torture, that we make sure that the reliability of the information is tested, that if we have concerns about reliability, we share those concerns with whoever we're giving the information to, either domestically or in foreign countries, especially if we're giving that information to foreign agencies. The fact that if we have a concern with reliability, we explain it fully, that we put other caveats on the information, caveats that would restrict its use. If information is provided to the FBI, do we want to put a caveat on that information that it only be used by the FBI for the following purposes? Now, we can't guarantee that those caveats will be followed, but we have a reasonable expectation, and we should, in fact, make it clear, if it comes to our attention they haven't been followed, that, in fact, we fundamentally disagree with that approach, and that we express at the highest levels our objections to the breaching of the terms on which information was shared. So we need to review all those procedures, and we need to create a culture. We need to reinforce through training a culture where, in fact, those protocols are treated seriously, that if we have a policy of caveats, they're always applied, and regardless of the circumstances, they are not ignored, they are not pushed to one side, because we see with Mr. Arar potentially what the cost can be when, in fact, those rules aren't followed.
And I do want to state that prior to me becoming a parliamentarian, I was an advocate for civil rights, and I want to commend the work that your department had done at the time to increase sensitization to the forces and increase interaction with Canadians. And training and education. So I thought at the time that those initiatives have gone a long way, and we're certainly benefiting Canadians and law enforcement agencies. I want to ask another point, is that, and it's relevant to what Mr. Holland has just asked. Do you have an opinion on the fact that now the RCMP has gotten back into intelligence gathering for national security, and there might be some duplication with CSIS? Do you have an opinion on that and how the relationship between these two agencies should be?
Mr. Justice O'Connor talks about that, and in fact, his first recommendation goes directly to the heart of that matter. I believe that there are lines that I think by force get blurred from time to time. But I agree with Mr. Justice O'Connor, you have to work really hard to try and keep the lines as distinct as possible, and that CSIS is there to collect intelligence. They are not a law enforcement agency. They do not do criminal investigations. And in fact, as Mr. Justice O'Connor found, CSIS conducted itself, at least in relation to this, quite appropriately in that they turned whatever information they had over to the RCMP. In relation to Mr. Arar and certain other intelligence that they had. They turned it over, and it was then up to the force to carry that information, to use that information in the context of an ongoing investigation, as I understand it. But there does have to be discussion between CSIS and the RCMP in terms of, I think, CSIS saying, we have the following intelligence, and the RCMP and CSIS talking together to determine whether that information is sufficiently concrete or substantive, that it is something that the RCMP would then pursue in the context of a criminal investigation. So that you do have to try and keep these two entities separate, and what they do separate. CSIS gathers intelligence. Some of that intelligence may ultimately be transferred to the RCMP for the purpose of an ongoing criminal investigation, which may or may not lead to charges at some point. The vast majority of information collected by CSIS or any intelligence gathering entity never goes to a law enforcement agency for ongoing investigation. It's not that kind of information that's collected.
Thank you. Monsieur Menard, you wanted another, you have another question?
Yeah.
Okay, go ahead.
If I understand the situation well, the situation in which you found yourself as a member of cabinet, you knew that sending someone to Syria was a very serious decision. You weren't aware of the Americans' reasons for having done so, but you also knew that if they had very good reasons to do so, in their own minds, they should have shared them with the RCMP because he was a Canadian citizen. You were aware that the RCMP had shared information with the American authorities before they came to, or took that decision rather. So the information that you were lacking was that that information was incorrect. Now, you had confidence in Mr. Zaccardelli when he was the head of the RCMP, the commissioner, and I understand that the relationship between the chief of the police service and the minister is such that the minister cannot be aware of certain things. There are things that the minister can be told, but there are also things that the minister must be told. So this kind of information, was it in which the category that the minister must know, must be aware of? The fact that erroneous information was communicated and it would have an influence on the American decision?
If the Commissioner knew that erroneous information had been given to the United States when I became Minister of Public Safety, that, in my opinion, is something I should have been told.
Bon. Maintenant que vous savez...
Now, does that affect your confidence in Commissioner Zaccardelli? Would it affect it?
I would want to know more about what the Commissioner exactly knew when, and I think that he's coming back here to you, and I will be listening very carefully as to when he knew erroneous information had been provided to the Americans. But certainly, again, my view is that had he known, or others as far as that goes, but had he known that erroneous information had been provided to the United States, he should have told me that.
Non. Maintenant, l'auriez-vous su?
Now, would you have known as a member of Cabinet that this might have been something that could be used in your communications with Syria to convince them that Mr. Arar should be freed? Could you have said to them, look, Mr. Arar is there on the basis of erroneous information that has been communicated to the American authorities, so free him?
There was erroneous information that had been communicated that might have in some way influenced either the United States or Syria in terms of continuing to hold him, it should have been made clear to the Syrians that erroneous information had been originally provided to the United States. Now, you and I both know that whether or not the Syrians would have acted upon the fact is a different question. But clearly, had we known that there was erroneous information, then that is something that one would put, I would obviously think, you would put in play with the Syrians and say, look, we hope you understand that Mr. Arar had been misdescribed in original information provided to the United States, and that would, one presumes, help buttress the request being made by the Minister of Foreign Affairs and ultimately the Prime Minister that Mr. Arar be returned home.
Oui, mais vous et moi savons aussi que si les Syriens...
Yes, but you and I know that the Syrians will not necessarily react the way we want. They don't act through because they have a mean streak. They are trying to get the information that will advance their own inquiries. And so if they're convinced that that person has nothing to tell them, they will free them more quickly.
No, I think
Okay,
I agree with...
Mr. Comartin, you indicated you might have a supplementary question.
I just want to pursue that same line of questioning, Ms. McClellan, with regards to the, I guess, this scenario. Assuming Commissioner Zaccardelli was not informed, and Justice O'Connor in his report indicates that the senior officers of A Division were not informed of this misleading information having been given to the U.S. side. Going back to the question you had earlier about, I suppose, about discipline, about accountability, we are being told that every single member of the A Division have been promoted, and that a number of the a number of the officers below the senior officers have also been promoted, and none have been disciplined. In the context of the information that I made reference to earlier, what was going on in the media in terms of these leaks, what was being said by the Americans about information coming from Canada, do you not agree that if we're going to change the culture, that there has to be some discipline at some level? There has to be some accountability somewhere if we're going to change that culture.
Well, I think accountability is key, as I've already said. I think that can take many forms. You don't change a culture. You can change a culture in many ways, one of which is by moving people out and other people in. One is through training and so on. So that I do agree that ongoing training is key. We need a culture where protocols are understood and respected, where caveats, the necessity for caveats and the testing of reliability become ingrained in any information sharing exercise. Whether or not that also entails the disciplining of individual members of a unit or the force, I think is a more difficult question. And I do go back to the fact that Mr. Justice O'Connor concluded that there was no intentional action on the part of the RCMP to harm Mr. Arar, that in fact misinformation was provided, and that misinformation came about because certain processes weren't followed. But having said that, there was no malice directed toward Mr. Arar, and in fact, Mr. Justice O'Connor concludes that no Canadian official was complicitous in his deportation. So I think you can't deal with the issue of discipline of an individual officer or officers without keeping in mind that context. I mean, I would say yes, if there were evidence that someone had deliberately misrepresented a situation to do Mr. Arar deliberate harm. Absolutely. That would be an enormous breach.
We're talking about omission here.
Yes.
We're talking, as Mr. Menard has suggested, that having that information at your level, at Mr. Graham's level, might have made a difference. Having that information available at the ministerial level would have provided you an opportunity to set the record straight and not further damage Mr. Arar's reputation.
That's right. Had we known,
I don't think we're demanding. I don't think we're demanding of our public servants at that level a standard that is unreasonable in that context.
No, I agree. Look, if a mistake has been made and if someone's reputation and or physical well-being is at stake, it is incumbent, I believe, on whoever it is, including ministers and prime ministers and members of parliament and whoever, it is incumbent upon us to acknowledge the mistake and try and fix it as quickly as possible.
And without that information being shared all the way up to the ministerial level, it's going.
You can't do that.
Okay.
Thank you, Mr. Chair.
You're done. Thank you very much. No more questions. Before we adjourn, I would like to thank you very much, Ms. McClellan, for coming to the committee here. We appreciate your testimony, and I think there's no further questions. But before we adjourn, I was asked to make an announcement. Last Wednesday, your offices received a copy of correspondence sent to the committee from a Jack Kinsler, a representative of the Israel-Canada Chamber of Commerce. He's in town until tomorrow with Mr. Rafi Sila, a senior partner with AR Challenges, who Mr. Kinsler informs us is an expert on matters of homeland security and public safety. He will be presenting today at a conference entitled Global Approaches to Security and Technology Strategies. Now, he's offered to meet with interested members of the committee, and I thought the best way to handle this is to simply let you know about that. They're interested in meeting during their visit or future visits. He has asked me to encourage you to contact him, and if you're not able to do it this time, he may be back. There's no more business to discuss, so this meeting is adjourned.